So there are two types of custody that we deal with in Georgia: legal custody and physical custody. So there are four main categories for legal custody: religious upbringing, educational decisions, non-emergency medical care, and extracurricular activities. And so the parents will generally have joint legal custody, with one parent having tiebreaker over each one of those four categories. And that can be divided up with one parent having all four tiebreakers, or splitting them 2 and 2 or 1 and 3, whatever makes the most sense for that family. The other type of custody is physical custody, and that's going to be literally where the children on any given day during the week. And there'll be a parenting plan that sets out day by day what the visitation schedule will be like, who gets the children on what holidays, and how summer break is divided up. And that's all done in the parenting plan. So best interest of the child is the legal standard that the court is to use in deciding custody decisions for the children. And it is in a statute in Georgia. It's OCGA 19-9-3. And there's a list of about 22 factors that the court can consider in deciding custody. So once a custody order is in place, that custody order is intended to be in place for at least 2 years, absent a substantial change in circumstances. After 2 years, you can petition for a modification of custody, and you have to show two things. First, the threshold question is, has there been a material change in circumstances for the children? And if there has, then the court's going to look at the best interest of the child standard and go through those factors to decide if a modification is in the best interest of the child. So oftentimes, if we are dealing with a modification, a common substantial change in circumstances is a parent having to move away from where they were at, and that geographic distance is going to require changing some of the schedule. It may require changing custody outright, depending on some of the other factors on the best interest of the child standard. So after divorce, moving, if you've got primary custody of your child, moving can create some issues, and you need to do this very carefully. First, in Georgia, you're required to give 30-day notice of any change of address to the other parent. So that's step one, is notifying the other parent of your move. You also need to have a conversation with that parent. How far away are you moving? Is this going to interfere with the regular visitation schedule? And if so, what do we need to do is to make those changes. If you're the non-custodial parent, this may be a cause for you to modify custody or visitation. It may be that the other parent's moving very far away with your child, and you want to petition the court to give you primary physical custody. My name is David Purvis. I'm with the Meneely firm. If you've got other questions about custody or visitation in Georgia, please give us a call.